Welcome back to the Newspaper Review, live on Citizen TV. This is the Power Breakfast Show. We carry on with my team of advocates here in studio discussing, I hope I've used team of advocates. Does that, yes. that works? Or panel of advocates. Oh, panel. Sounds much better. Panel of advocates here in studio. We're talking about matters regarding the Supreme Court. We'll be crossing over to the Supreme Court as well in the next couple of minutes or so. Francis Gashuri, Sam Gituku have camped, literally pitched camp there for the last couple of days following the proceedings there. And we'll be going over to them to get their expectations, a preview of what you can expect from the Supreme Court today. We expect one of the longest hearings to happen. If you calculate how much time everyone was given, we're talking about roughly 12 to 13 hours or so. At the lunch break there, possible other breaks for consultation. We could be in for a long time today. So if you're following that, just be ready for very long proceedings. But of course, another topic that many people are discussing, and it's the reason why I think one of my guests here in studio was late, is because some of the roads have been cordoned off. Kibe, I think, was it you who was telling me that you tried to pass through the city center and along the way you found that you were unable to access particular roads? And
I'd forgotten about one of the roads. It was like to be cordoned. But the
necessary or excessive is what
on the face of it looks excessive, but sometimes when threats were given that probably we might jam the court, we might hold activities around the precincts of the court or around the court area, you are likely to have a kind of these overreactions by the Kenya police. I think I've seen they tend to do that, to err on the side of caution, where you do a lot of security, yet it should be a free environment. In fact, that is precisely where I was talking about the idea of an open justice system. It is where, like, it is possible for an ordinary mwananchi to be able to walk into the court.
If they feel that they would like to follow this closely.
And if now it is only for space. But in principle, let it there be that you can actually attend, but when you reach there, let it be that at least you reach the gates of the court and we say, we have enough wananchi already. Try your luck tomorrow, try and come a little bit early. But the idea that in the first place you can't even access the Supreme Court, I don't even
roads around the Supreme Court,
unless you are actually doing the case. You cannot, even for purposes of some curiosity. You just have to watch it on TV. It doesn't look good to me.
Joy, before you comment, let me actually read the headline. This is page 9 of the Standard. I'm sure it's also referred to in the Nation as well. Police sealed off the Supreme Court to block a vigil in support of the presidential election petition filed by NASA, this being the petitioner Raila Odinga and Kalonzo Musyoka. Whereas on Saturday, officers blocked major roads near the court. Yesterday the operation was extended to the informal settlements where security personnel patrolled on foot, discouraging people from heading to the city center. I'll also hopefully be able to show you, okay, so yeah, some of the roads that you're not able to access. It's important you note this in case, so that you don't fall victim to the same challenge that Kibe Mungai faced this morning. And that's a bit of what you can see on your screen. City Hall Way, Taifa Road and part of Wabera Street. These roads will remain closed to pedestrians and vehicles possibly up until Saturday. So if you use those roads on a day-to-day basis to access, offices in town or wherever you need to go, if you work on those roads, quote unquote, I guess you're
on holiday.
You're on holiday. Joy, go ahead. Your thoughts. I don't think you're on holiday. But nevertheless, how will you access?
I find it ridiculous. It's absolutely ridiculous in this democracy, in this day and age. Why? For what adventure? They're inside the law courts. The law courts are secure precincts. If you don't want people marching there, dispersing the crowd is something that is very simple to do. We have held international conferences with more dignitaries and a lot more traffic going, and people were still able to carry on with their life. If you want to go now to pray at Holy Family Basilica, you're in trouble. If maybe you want you have business in KICC, you're in trouble. I don't think it is necessary for the delivery of judgment for this particular level of, I don't even understand it. In my opinion, it is ill-advised. I agree with Kibe, it is an overreaction. But at the same time, I can understand where they're coming from, because people have tried to have a vigil at the law courts. Then you can see, maybe they'll see, maybe there's intimidation, or there's, maybe the noise would carry inside, and so they've decided, you know what, just stay away. But I think there would have been a better way to do it.
You think there would have been a better way to do it?
We are not at war.
Okay, Kaikai?
I think
was there a better
I
way?
agree with them a little bit and disagree a little bit. Having had the benefit of sitting there, when you look at that court, it's in the middle of roads. There's Taifa Road, there's Wabera Street, and behind this, the KICC, I think, is that street is called what? Parliament. And I'm telling you, it's very noisy. And the last I checked, that Supreme Court is not soundproofed. And you have very limited time in terms of judges hearing the lawyers. And Kibe and Joy have practiced that. When people are hooting, people are passing pedestrians there, the noise is all filtrated in there. So I think one of the consideration of the court is just how secure are we in terms of sound, so that we don't have a lot of interruptions. That's the key thing here. The other thing was what Kiba and Joe have talked about in terms of the fear that outside there people will be doing what was it called? Some demonstrations or picketing
and vigils.
So one is and vigils. Actually, that's the word I was looking for, and vigils. So one of it was to guard against vigils, and number two, one of the reasoning could have been the issues of noise.
Okay.
Yeah. So it might look.
So you think it was made?
It might look excessive, but it's to an extent justified.
Okay, it might look excessive, but it's to an extent justified.
I think it is blocking. When you block with these those trucks that are used to disperse crowds, is the one that's the intimidating aspects of it. But it's possible to close a road, and very many times they block a road.
They came in very handy.
Let me ask: Can somebody move to a lower court and ask that those cordons be declared illegal? Help me understand the legality of that particular process. But if I have an issue, can I wake up this morning and say that I want to be allowed to access those sides? I'm not accredited in any manner, but I feel it's my constitutional right. Can I move to court?
There's very many rights for very many things. Freedom of association and movement and things is guaranteed. But in such a situation where the police are trying to maintain public order, you find that many courts would be reluctant to interfere.
Okay.
So theoretically, you can go and try and access it.
Okay.
It will cost you time and money, and you might be still unsuccessful in the end because they have given the justification for it. And like Kissinger says, when you work in the law courts is when you can appreciate what the vagaries are.
Okay.
Maybe the discussion should be: can we build better facilities? Can we soundproof the court? Can we maybe find a safe trip in and out for the judges so that they don't have to worry about?
Or they have multiple exits so that it would be easier
rather
to
than
leave
inconveniencing every single person. Because even just when they close off the parliament section, just that section, it usually causes such mad traffic in the CBD.
Okay.
The discussion has to be had with maybe some of these facilities ought to remove from the city center. Or just let's make sure that Wananchi are able to have their lives without this level of interruption whenever there's something important going on.
Because you can expect a lot of traffic around those areas.
Oh,
this week, all the best. I mean, quite a challenge for those who'll be working around there for this particular week. But at least you've been forewarned, and you can, better plan yourself and not fall into any challenges. Now, there's a story that's been covered actually in both papers. I'll briefly touch on the headlines, on the titles in both papers, and allow my panelists here to engage a little bit on that. Standard, it's on page 5 for both of them. Page 5 of the Standard reads, 22 election losers lodge petitions. Some 22 election petitions have been filed across the country by Friday last week. Out of these, 20 were filed by those who lost their bid for member of county assembly. Interesting. According to a report that's been seen by the Standard dubbed Status of Election Petitions Filed as of 25th August 2017, meaning 2 were filed by those who lost their bid for other seats. I'm not quite sure where. Hopefully, one Senate seat and I guess another, for a different post. While in the Nation, and I'll just touch on this briefly because I know time is not on my side, losers have until September 6th to file petitions. That should give you an idea of deadlines in case you would like to file a petition. Individuals intending to file poll petitions have until that date. Despite threats by many losers to file the petition, this is where I want to bring you in on that. Few have been to the committee with just 9 days to go. Kai Kissinger, we had about 14,000 candidates in this election. We know that only 1,000 or 1,000 plus, just a little over 1,000 got jobs or have the title elect or if you know, if they've already been sworn in. And so there are about 13,000 who lost. Many complained in the media, many refused to concede, but only 22 have, you know, started the process of appealing or petitioning. Yeah.
Yes.
Surprising?
It looks no, it's not really surprising. It looks a small number, but it's a huge number as well.
22 out of 13,000.
Yes. Remember one thing, that it's also prohibitive. Filing an election petition, you have to there's a cost involved in terms of filing, and also the legal fees to hire a lawyer. So that's the reasoning. But what is of concern now is what levels of preparation the judiciary has. I think when the judiciary released its report, they said that they are prepared to deal.
They are ready. That's right.
With the election petition, and they were thinking that they are budgeting about 43 cases will be filed. That's
actually 200.
200 cases will be filed.
Prepared
200 cases will be filed. So what's important is that the judiciary is ready. They have published it. They have said they are ready to deal with that. But remember one thing, I do not know, and my colleagues will help me here, I do not know what could be the impact if the petition takes a direction that
some are hoping for.
And we don't want to go to that direction. But that will have an impact probably whether some other caliber of candidates might want to think of filing. I know that some people are just preparing to go further in terms of that. But I think it's the prohibitive nature of filing this petition that probably keep people away.
Okay. Yeah. Okay, but in summary, what you've tried to hint at before I allow you, Joy, to come in is that whatever decision will be made on September 1st could determine, that's at the Supreme Court, could determine whether some other, you know, those who lost their bids might decide to go to court also, or be emboldened actually.
That's what I think. I think because of the impact in terms of how the decision will take. But my colleagues can.
Okay. There's one thing that is notable with this particular round of elections. The judiciary did a lot of training of their judicial officers in terms of how to handle election petitions, and they also went ahead. In fact, the Judicial Training Institute went ahead and trained the members of the Law Society on how to handle election petitions. And one thing that came out very clearly was the level of the burden of proof and the level of proof that needed to be attained. Remember, prior it used to be, oh yes, this was not done, this was improper, cancel the election, people go back to, and there are very many by-elections. This time around, a very important ingredient is Section 83 is a very important ingredient this time around, and the judges and magistrates are very categorical. Before you come with your client to court, be ready to demonstrate how whatever was wrong with the election would have changed the election in favor of your client. Now, if you cannot prove that, don't bother coming to court, because you will not be successful. Now, I'm sure there are people who have presented themselves before advocates, and if you do not have, or if all you have is my agents were chased away from 2 stations, and I don't have all the paperwork, they'll be told, look, it will be an exercise in futility. Now, that is also a very, and I agree, so people are broke, so it's an expensive venture. So
there could be several issues, including the fact that you might have quote-unquote losers who went to see their advocates, and at that point were told, leave this thing alone. This is not going to work. Case in point, I'm thinking of somebody like Lenny Kivuti, the challenge that was against Governor Wambora. We must have gotten to a place where you're told, look, you may have seen 1 or 2 things that were not in place, which is true, and you can bring that out, but unless you can prove this, there'll be no overturning. Because one thing the judiciary was minded not to do this time round is have the level of by-elections that we had last time, because you realize many election losers went to court, filed a petition, was successful, but when the by-election came, the electorate still did not pick them. So you find that it was an exercise almost in futility, and that is one thing that they were trying to mitigate. So it's possible that there are people who presented themselves to advocates and are told, look, this standard is quite high. Too high. So unless you have got all your ducks in a row, let's not even bother, because at the end of the day, you will not get the result that you're hoping for. So in my opinion, that and the expenses, you must have a security for costs now. Unlike before, where you condemn to costs and then you do the run around. Now you have to present the 1 million before for security. So and people have run a very expensive campaign. I doubt it's financially. So with the 22 we have now, they might not be many more. But you know, but some of them have a good ground. Like for example, if somebody was declared a winner and the Kims kept adding up, and then you emerge the winner afterwards. I mean, you're a guy who you can show that
The
There was an
result ought to have
issue.
been
The
different.
Kings
Okay.
was statistics.
Keep it coming.
To speak the truth,
Statistics.
the projection of the judiciary, given the number of candidates in all those elections, you'd have expected that there should be more petitions.
Yes.
Of course, I expect more will be filed. We are last-minute people. As September 6th approaches.
Tyranny of time.
Yes, tyranny of time. So I think that we are likely to see more petitions being filed, but there will still be relatively fewer given the number that have been filed as of now. But there are three quick reasons that I believe these are few. When you look at the elections, and I think because of what Kissinger was calling over reform, I think these reforms have had one more impact.
Yes, yes.
That the general elections of Kenya was not bad in an obvious sense.
Exactly.
And that is why everybody say this was okay. So in an election that you cannot say was bad, like for example when you see 1992, when you read the reports of how they do it in Uganda, you are physically being prevented even from campaigning, you are being intimidated openly by the police. These things are no longer there in Kenya. And therefore it contributes to ensuring that you do not have the so-called obvious reasons. Issue number two is what I called the polarization of the country. What has ended up happening is that if you come from the Jubilee areas, the Jubilee candidate is going to have a big margin vis-a-vis each other. Because you see, the good candidates from a lawyer's point of view for an elections petitions is where the margin is close. Because now you can be able to easily convince the court that had there not been problems in these few areas, I could have overturned these results. But big margin, and you have the same case in the presidential elections, a very big margins makes it very unlikely that the elections would be overturned. And in Luo Nyanza, even at the coast, even in most of central Kenya, the margins were huge. So it makes it very difficult.
So a potential petitioner will sit, do the math and
say how do you convince a judge to overturn these? Then the final reason, of course, has a few things to do with civic education. And what I mean is this. I've spoken to 3 or so candidates, people whose their elections, it is possible that if they had a better understanding of how the system actually works, would actually have been able to pick for you some good evidence to challenge the ultimate results that were there. But now you see a scenario where the impressions you have is that a candidate didn't seem to do a good job in terms of having people watching this or the other and bringing you evidence. So that on the face of it, you can see there was a problem. But again, you ask him, who is going to be our potential witness? There are no witnesses. Because obviously the candidate was not prepared for, assuming I don't lose, if I don't win, what kind of things would I show? So he's not prepared.
You are prepared for the win, but not prepared for a loss.
Precisely, and now to challenge it.
Kibia, I'll have to stop you there. I'm sure each of you have received calls from different candidates, so I'm sure you're all speaking from some sort of experience. But I need to cross over now to the Supreme Court, where Francis Gashuri is on standby to help paint a picture of what you can expect from the Supreme Court today. We know that they're expected to start hearings from 9 a.m. and the beginning of that particular process is where the 7-judge bench is expected to rule on the application by Raila Odinga, petitioner, and Kalonzo Musyoka on whether they'll be given access to IEBC servers and also original copies of Forms 34A and B. Francis Gashuri, good morning. Help us understand what we can expect from the Supreme Court today.
Wahigamura, a very good morning to you, or should I say a very supreme morning to you. And right here we are still waiting for the arrival of the lawyers and the judges. It is a big day, a very long day so to say, and some of the lawyers I can see from where I am, they've already started making their way here. I've spotted Jackson Awele, one of the lawyers for the petitioner, that is Raila Odinga and Kalonzo Musyoka. And so today, this morning, before the submissions proper begin, I will be expecting to hear that ruling by the 7-judge bench of the Supreme Court on a very important application that had been made by the petitioner, that is Raila Odinga. His application or his prayer is to be allowed to access the IEBC servers and the Kenya Integrated Electoral Management System, that is the KIMS system, for audit and verification of the results that were announced at the polling stations and declared at the constituencies, because in his opinion there was monkey business that was done to those systems, and so he wants a comprehensive audit of the systems, just to ascertain that that which was announced at the polling stations is exactly what was announced at the National Tallying Center and used to declare President Uhuru Kenyatta president-elect and the victor in the August 8th presidential contest. And thereafter, after that ruling, definitely it will provide the way forward in terms of how the process will be moved on, because at the heart of the petition that has been filed by Raila Odinga and Kalonzo Musyoka is that there were a myriad of irregularities, and that the entire presidential election was a sham. Actually, in his opinion, an algorithm was introduced to tinker with the numbers and give it a predetermined outcome, and that is why he's claiming that the president and the deputy ni vifaranga vya computer, in his own words, that they are computer generated, and so he wants to prove that assertion that they were generated by the computer through an algorithm. IEBC, on the other hand, has insisted that its servers and the KIM system requires a lot of security, and so to allow a third party to come in and audit the process, they would require at least 3 weeks to back up the systems. And so those are the matters that the judges will have to deal with this morning in terms of determining how that process will be undertaken. Remember, there's also an application to audit and verify the original Form 34As and Form 34Bs that were used to record results and transmit results from the polling stations and the constituencies. The 40,883 Form 34As and the 290 Form 34Bs that were used to declare results at the Bomas of Kenya. There's that tallying, the audit of those documents, and at the same time the audit of the servers, the opening up of the servers and the KIMS system as requested by Raila Odinga, the petitioner. So that is the first order of business this morning at the Supreme Court, when the judges sit to hear and determine this matter. Thereafter, Wahiga, the petitioner, that is Raila Odinga and Kalonzo Musyoka, will have 5 hours to make their submissions, their oral submissions, before the 7-judge bench. And so basically you can say today is the petitioner's day to lay his case and show how, in his opinion, the August 8th presidential race was marred with irregularities, and to prove his assertion that the presidential election results should be nullified and a fresh election called within 60 days of the court's verdict.
Welcome back to the Newspaper Review, live on Citizen TV. This is the Power Breakfast Show. We carry on with my team of advocates here in studio discussing, I hope I've used team of advocates. Does that, yes, that works? Or
panel of advocates.
Oh, panel. Sounds much better. Panel of advocates here in studio. We're talking about matters regarding the Supreme Court. We'll be crossing over to the Supreme Court as well in the next couple of minutes or so. Francis Gashuri, Sam Gituku have camped, literally pitched camp there for the last couple of days following the proceedings there, and we'll be going over to them to get their expectations, a preview of what you can expect from the Supreme Court today. We expect one of the longest hearings to happen. If you calculate how much time everyone was given, we're talking about roughly 12 to 13 hours or so. At the lunch break there, possible other breaks for consultation. We could be in for a long time today. So if you're following that, just be ready for very long proceedings. But of course, another topic that many people are discussing, and it's the reason why I think one of my guests here in studio was late, is because the roads, some of the roads have been cordoned off. Kibe, I think, was it you who was telling me that you tried to pass through the city center, and along the way you found that you were unable to access particular roads? And
I'd forgotten about one of the roads. It was like to be cordoned. But the
necessary or excessive is what.
On the face of it, it looks excessive, but sometimes when threats were given that probably we might jam the court, we might hold activities around the precincts of the court or around the court area, you are likely to have a kind of these overreactions by the Kenya police. I think I've seen they tend to do that, to err on the side of caution, where you do a lot of security, yet it should be a free environment. In fact, that is precisely where I was talking about the idea of an open justice system. It is where, like, it is possible for an ordinary mwananchi to be able to walk into the court.
If they feel that they would like to follow this closely.
And if now it is only for space. But in principle, let it there be that you can actually attend, but when you reach there, let it be that at least you reach the gates of the court and we say, we have enough wananchi already, try your luck tomorrow, try and come a little bit early. But the idea that in the first place, you can't even access the Supreme Court. I don't even
roads around the Supreme Court.
No,
unless you are actually doing the case.
Yes.
You cannot. Even for purposes of some curiosity. You just have to watch it on TV. It doesn't look good to me.
Joy, before you comment, let me actually read the headline. This is page 9 of the Standard. I'm sure it's also referred to in the Nation as well. Police sealed off the Supreme Court to block a vigil in support of the presidential election petition filed by NASA. This being the petitioner Raila Odinga and Kalonzo Musyoka. Whereas on Saturday, officers blocked major roads near the court. Yesterday, the operation was extended to the informal